How you guys doing today? It's Anthony Ganji. Welcome to another episode of Tear Talk. Hey guys, the Melodee Buzzard case. The young girl still missing. Mother is on cooperative. And social media has questions that they want answered. Look at this little beautiful girl. They want to know, why can't law enforcement just rush in and get the answers that they need so we could protect this little girl? So it's the rights, constitutional rights of the mother of a United States citizen versus the safety of a child. So I was doing some research, and I think I came up with some of the answers to your questions, but hopefully this is to really build discussion. I'm learning just as you are. So this is a great chance to take advantage of what we can learn, because you never know what one case, what you can take from one case that could be applied to other cases. And that's what I'm trying to do here. I'm trying to find critical moments in each case that we could take a lesson from. And right now, the lesson here is the rights versus the safety of a child. Or the rights versus safety, technically. Where's the line? So what I want to do first is I want to give you a quick little recap of this case, if you haven't heard of this case before. And by the way, I did a video on this yesterday as well that touches on homeschooling and child protective services, because we believe there's two components there that have to be revisited. But let me just give a recap, and then I want to show you guys a quick interview that Nancy Grace did with the aunt. And then we're going to go ahead and go over rights versus safety of a child. And I got some questions I want to throw your way, because to be honest with you, I may not even have all the answers. But I do want to toss it out to you guys, because as I see the social media page on Facebook of all the comments, it's a very smart crowd on that social media page trying to help find Melodee Buzzard. But just real quick, let me just give you the quick summary of this case. So Melodee, right here, was officially reported missing on October 14, 2025, when her local school in the Lompoc Unified School District flagged her as having a prolonged absence. And there's talks about that, why they take so long. Again, we discussed that in the episode yesterday. Authorities believe Melodee was with her mother, Ashlee Buzzard, as recently as October 7th, when they reportedly traveled in a white rental Chevrolet Malibu. License is 9MNG101. The journey may have reached as far as Nebraska. They say it's like a 20-hour drive from where they were at. Ashlee currently remains on cooperative. She has not provided investigators with Melodee's whereabouts or conditions. And the Federal Bureau of Investigations, FBI, has joined the case due to the multi-state travel potential, and family members have not seen Melodee for over 4 years. And there are concerns about Ashlee's mental health and prior child welfare interventions. Talks of Ashlee's mother being bipolar. So what we know is Melodee's absence triggered a missing persons investigation. That's where we're at now. It's just a missing persons investigation. She was homeschooled, but district record shows she never picked up independent study work. And investigators have searched the home, executed a warrant, and are pursuing leads, including surveillance, vehicle tracking, and tips from the public. But what we don't know is Melodee's exact current location, the condition she is, whether she's safe or in danger, a clear reason why her mother is non-cooperative, whether a crime has definitively been committed. The case remains classified as just a missing person investigation. So what we want to watch for, any confirmed sightings or credible tip placing Melodee after October 7, 2025, changes in Ashlee's cooperation, whether she gives information or location, interstate agency involvement or travel records unsealed, and public calls for information or alert distributed to law enforcement. Now, saw on Facebook today, so right now it's 10/22, October 22nd, they said that CPS was still at the house, but it didn't look like the mother was cooperative. All right, let me show you this quick little interview real quick. It's with the aunt. I want to show you this.
Where is this little girl? Where is Melodee? How Could she be gone a year and just reported missing, or was she?
Timeline was very sketchy, and mom is not giving any information at all. She will not answer the door. She will not answer questions. Is Melodee okay? Are you okay? She said, I hope you and your kids are well. And she shut the door.
The bizarre disappearance of a little girl.
The FBI is looking for her. They're trying to find her. No one has seen her.
Where is she? Why did the school have to report her missing? Where is Melodee? Please help us find this girl. Elizabeth Mesa, this is Melodee's aunt. Miss Mesa, thank you so much for being with us.
Yes, thank you so much for having me.
I'm so grateful that someone in Melodee's family is speaking out on her behalf. There she is. I recognize that outfit. That's a Dorothy outfit from Wizard of Oz. Must be a little Halloween or a costume party of some sort. Look at this little girl, guys. Have you seen her? Tip line 805-681-4150. Repeat, 805-681-4150. Straight back out to Elizabeth Mesa joining us. This is Melodee's aunt. Miss Mesa, how can this be? I don't understand how a child cannot be seen for a year and only just being reported missing. But is that accurate? Isn't it true Melodee was homeschooled?
Yes. So when we found out last Tuesday, the investigator reached out and was asking questions and, about her whereabouts. So to hear that she was missing was completely mind-blowing, and to find out she was homeschooled by the mom, and the last time anybody seen her was a year, and then it turned out to be 2 months ago was the last time that the school had seen her. So the timeline was very sketchy, and mom is not giving any information at all.
Speaking of mom, are you or is anyone within the family in touch with the mom?
So she answered the door for my niece, Karina, which is Melodee's sister on her dad's side. She opened the door and answered very little questions, but as far as anybody else, no, she will not answer anybody. She will not answer the door. She will not answer questions.
Now, what do you mean she answered the door, but she wouldn't answer question?
I know it sounds weird, Nancy, but she stood there very stoic with a very stone look on her face. And my niece asked her, where's Melodee, if she's okay. And she said, why now? Why now? And my niece said, well, we couldn't get a hold of you. We had no address. We had no phone number. And she said, well, there's a reason for that. And my niece just kept asking her, is Melodee okay? Are you okay? And she said, I hope you and your kids are well. And she shut the door.
So you got nothing out of her. Guys, we're
Nothing.
showing you shots of Melodee right now. She's been missing. We don't know how long. We're not sure she actually is missing, but I do know this. Again, guys, with me, family member Elizabeth Mesa joining us. This is her aunt. A staffer at her elementary school realized that Melodee had not been there, or, well, she's homeschooled, but they have these little programs that the homeschool children take part in. Right. And so the school doesn't see her every day like you would a child enrolled in regular school. But when Melodee had missed several of these get-togethers with the homeschool children, like field trips to the planetarium or the zoo, the staffers at the elementary school got concerned. And that is when it all came bubbling up. So to you, Miss Mesa, again, thank you for being with us, because we've tried really hard to get in touch with family members. When did you first realize Melodee was missing?
So we first realized or found out last Tuesday. I believe that was the 14th, when the CWS investigator called me asking if I know her whereabouts. And I had asked him, is my niece okay? And he told me, I can't answer that because it's an open investigation. And he said, we're just looking for her whereabouts. And I gave him all the information that I knew, and I let him know that the last time physically we seen her, the family, was about 4.5 years ago when her mom brought her to my mother-in-law's house for us to see her. And at that time, Nancy, she was acting very strange. She had shaved her head down. I mean, she had like a buzz cut, and she had a hoodie on. The mom, Ashlee, did. And she was acting very strange. And my mother-in-law had told her, if you want to leave her here, she could stay here, because she was playing with my kids. And Ashlee looked and she said, I can't do this. And she grabbed her and they left. And that was the last time that we seen her.
And isn't it true, Miss Mesa, you guys have a really big family, a big loving family, and everybody wants to take care of Melodee, but the mom wouldn't let you.
Yes, that's correct. My husband, his family is very large. I mean, and so loving and opening. And Karina is her sister, like I said, on her dad's side. Her dad passed away 9 years ago in a tragic motorcycle accident. And she's always wanted a relationship.
Are you talking about
with her
Rubiel?
sister. Yes, my brother-in-law, Rubiel.
Melodee's dad, Rubiel, died in a motorcycle crash, and that was 2016. So
Yes.
It's just her and the mom. Now, was Melodee always homeschooled?
Well, we just found that out, Nancy. We had no contact with her. Like I said, the last time we were informed that she was removed from the mother's care. And we all tried to, get her, she could be with me, she could be with, whoever they would allow her to be. And then she was finally able to be placed with my brother-in-law and sister-in-law. And they had her for quite some time. I don't know exactly how long. And then the state came back and they removed her, and they told us that she was going to be adopted by the family that had her before, or something like that. It was just so off. They wouldn't give information either.
All right, so there's a lot here. Again, I really detailed the case yesterday, but I want to kind of keep this moving and try to answer the question. So we are going to talk about her rights, and then we'll also try to balance that with when to supersede, when you can supersede those rights. Now, granted, I got some questions out here for you guys as well, because I'm learning in the process. I love doing these so I can learn. So I thought this would go well with the discussions that are happening on social media. So this is the constitutional right versus life preservation, the Melodee Buzzard case. So it's definitely something that requires a discussion. So the frustration is palpable and understandable. A vulnerable child is missing. Her mother appears uncooperative and the clock is ticking. The public instinct is simple: make her talk. But the American legal system operates on carefully constructed framework that even in the most emotionally charged situations, it still must balance urgent action with constitutional protections. This tension isn't a bug in the system. It's a deliberate overreach while still allowing for emergency intervention, which when lives hang in the balance. The Melodee Buzzard case crystallizes this dilemma. How do we protect a child's life without creating precedents that could be used to trample anyone's right in the future? So I want you to think about this, guys. And again, we're going to provide multiple perspectives here, but right now we're focusing on the rights. If investigators waited too long to invoke emergency powers and Melodee is found deceased, who bears responsibility? The officer who followed the rules? The system that created those rules? Or does anyone? And what if you were the detective who had a gut feeling but not enough legal evidence to act? Could you live with the following protocol if the worst happens? And you guys, you see it on the internet. The social media, they're like, just go in. And then there was a dialogue on one of these long crime show where the prosecutor and a psychologist were being talked to on part of the panel. And the prosecutor's like, we got to go brute force, get the mother to talk, because there's a timeline that people have in their head. So they're assuming the longer you wait, the child could be in danger. And then the psychologist was focused on the mother and possibly mental health disorders, bipolar disorder. And she's like, you got to approach her with kind of like care, compassion. And I understood the blend. So it looked like they were going to have a back and forth, but what the prosecutor meant was you got to go in, get her, put her in the station, then you could start working on the tactics. And that's where the psychology would be in play. But it was funny because they both looked like they were talking on different sides of the spectrum, but then they realized that they're not. And it was great because eventually they were willing to listen. And there was another gentleman as well who kind of saw the middle ground there. So it's great because sometimes we look at these extremes, but the answer's here. So the constitutional fortress. So why does Ashlee Buzzard have legal protection? So you got the first, the amendment that I see right now that's coming up throughout that whole social media is the Fifth Amendment, the right against self-incrimination. And I think everybody sees that. It's all throughout social media. So I put that in. So what does it protect? Obviously, the Fifth Amendment establishes that no person shall be compelled in any criminal case to be a witness against himself. This means Ashlee cannot be forced to provide testimony or information that could be used to prosecute her criminally. So how does it apply here? If Ashlee knows where Melodee is, revealing that location might also reveal her own criminal culpability. So you got abandonment, endangerment, or worse. Even in civil context, she can invoke the Fifth if answering would expose or could expose her to criminal prosecution. And this protection applies during police interrogations, grand jury proceedings, court testimony, and even informal questioning if she's in custody. So that's a right that she has throughout this whole process. But here's the public safety nuance. There's a narrow exception called the public safety exception. I saw that. And guys, if you know more about this, please do, guys. Please comment, hit it up, because I grow with these dialogues as well. It was established in New York versus Quarles in 1984, which allows police to ask questions necessary to protect public safety before reading Miranda rights. However, this doesn't eliminate the privilege. It just makes certain pre-Miranda statements admissible. Ashlee could still refuse to answer. So why does this matter? Forcing her to speak could result in, and now this is more about back-end concerns if you decide to take this to court and to trial, if she gets charged. Any statement being deemed coerced and inadmissible, potential dismissal of charges based on constitutional violations, creations of grounds for appeal if she's convicted, and possible civil liability for law enforcement. Because as they're doing this and they're trying to find where the child is, they also at the same time making sure they don't mess this up in case they have to hold her accountable. So there's the balance there. So the question to you guys is, what if Ashlee's lawyer knows where, let's say Ashlee has a lawyer, but she may not, we don't know, but let's just say she did. What if Ashlee's lawyer knows where Melodee is because Ashlee told them in confidence? Attorney-client privilege means the lawyer can't reveal that information either, even to save Melodee's life. Is that true? My research says that's not true. They have some level of obligation to report to authorities if there's a chance that someone is in danger or a chance of being harmed. So lawyers do have a responsibility at that point to report. But if it was a past crime and the person's not in danger, it's already done, does the lawyer now have to still report it? So basically one would be, hey, she's going to die if she doesn't get any food, blah, blah, blah. The lawyer will most likely have to report that to the authorities and try to do it in a way that protects his client. But if Ashlee was to say, hey, she's already dead, there's nothing you can do, this is where she is, what's the lawyer's obligation now? because it's a past crime. Does the lawyer have to report that? Love your thoughts on that, because it's different. Everywhere I looked at that, it would be different. So the past crime adds something to it. Should there be a dying child exception to attorney-client privilege? And if we created one, would anyone ever trust their lawyers again? Would that make our justice system better or worse? As I said, they're going to have to report that. I know that enough. If there's a chance someone's in danger, they haven't, they're still alive, they haven't been harmed, but they're in immediate danger. That's the key. That's the threat. The lawyer, I believe, would be obligated to have to report that. I have a note here on that too, because there were some people saying that the lawyer doesn't have to report that, and I don't agree with that. I mean, both morally, and I just don't agree with that. So I had something here. Normally, anything Ashlee tells her lawyer is confidence is protected by attorney-client privilege. That privilege is one of the strongest protections in the law. Lawyers generally cannot reveal what a client tells them, even if it's incriminating, but there is exception, preventing death or serious harm. Most states, including California, where Melodee was last seen, follow the ABA model rules of professional conduct. Under Rule 1.6b1, a lawyer may disclose confidential information if they reasonably believe it's necessary to prevent reasonably certain death or substantial bodily harm. This is a permissive exception, not mandatory, meaning the lawyer is allowed to reveal it, but not always required to. So I guess there's a bit of a difference there, because they're not violating the lawyer-client confidentiality, but they're not always required to. I didn't know that. So again, you learned something new. If Ashlee told her lawyer Melodee is locked in a place where she can't survive long, the lawyer would almost certainly be permitted and arguably ethically obligated. That's what I'm thinking, to alert authorities immediately to save the child. If Ashlee said Melodee is safe with relatives, but I don't want to hand her over, the lawyer might treat that differently. Privilege would still apply because there's no imminent threat of harm. So yes, counsel could tell police if Melodee's life is at immediate risk. That would not be considered breaking privilege. It falls under the life or death exception. If there's no imminent danger, privilege holds, and the lawyer cannot legally reveal Melodee's location without Ashlee's consent. So it's funny, because that's more about the violation of client-lawyer privilege, or lawyer-client privilege. So I guess they're not required, but technically, ethically they should. So that's good to know. I would still think if the person's in danger or getting ready to be harmed, they should do the right thing. But again, that was more about the violation of the right. So technically they could do it and they wouldn't be in violation, but it doesn't seem like it's required. If you guys know more about that, let me know, because there was also something else I read on that, by the way, just to kind of, if you guys are interested, I wanted to show you something else I looked up. It's again with attorney-client privilege. Anything a client admits to their lawyer about past crimes is completely protected by attorney-client privilege. That means if Ashlee Buzzard told her lawyer, I hid Melodee a year ago, or even I harmed her in the past, the lawyer cannot report that to police. That's part of lawyer-client privilege. What's your thoughts on that? Is that true? And privilege is designed to ensure clients can be honest with their attorneys without fear of immediate exposure. The key exception is preventing future harm or death. That seems to be the center of all this. If the client admission reveals that a person is in imminent danger or death or serious bodily harm, many states allow or require the lawyer to disclose enough to prevent that harm. Example, if Ashlee said Melodee is locked in a shed without food and will die if no one finds her, her lawyer could legally contact authorities, because that's about an ongoing danger, not just a past act. But if she said I already did something to her months ago and she's gone, that's a past crime. Privilege holds and the lawyer cannot reveal it. I also view admitted a crime to a lawyer kind of changes the ballgame a little bit, what they have to do ethically, but I'm not getting that here. If Melodee is alive but in danger, counsel could break privilege to protect her. And it says they could. It doesn't say they must. So that to me is a really good defense. And that to me is a concern when obviously something like this, a child missing right now and could be at risk. If Melodee is already deceased, privilege locks in. The lawyer cannot disclose the admission, no matter how disturbing. I love your thoughts on that. If you think that's, if you know something different, but that's what I looked up. Again, it's just to learn, but this is good for dialogue. Then there's the Sixth Amendment, the right to counsel. So what it protects. Once criminal proceedings have begun, so the arrest, the arraignment, the indictment, the Sixth Amendment guarantees the right to have an attorney present during questioning. So how does this apply? If Ashlee has been arrested or charged, all questioning must occur with her attorney present unless the explicitly waives this right. Unless she explicitly waives the right. Any interrogation without counsel after she's invoked the right would violate Messiah versus United States, 1964, and even clever tactics like using informants or undercover officers to elicit statements can violate this right once formal proceedings begin. And kind of dealt with that with the Emmanuel Harrow case, right? The Perkins operations. But again, they're not confessions, they're voluntary statements. So that's been challenged in court too. But you saw that with the Emmanuel Harrow case with Jake Harrow and Rebecca Harrow, but then the media dropped it, and I think it messed the operations. So the practical impact, the competent defense attorney will almost certainly advise Ashlee to say nothing. This is standard legal advice, not an indication of guilt. The attorney's job is to protect their client's interest, and speaking to police really helps the defendant's case, even if they're innocent. Do we know if Ashlee could be represented by a lawyer right now? I mean, if she was, I'm sure we'd know. Why violating this right backfires? Statements obtained in violation of the Sixth Amendment or are completely inadmissible. The violation contain other evidence discovered as a result, the fruit of the poisonous tree doctrine, and it can lead to sanctions against prosecutors and law enforcement. So if they did get something without going through that, then whatever they found probably wouldn't be able to be introduced. So again, remember, they're doing two things at once. They got the safety, which should be paramount, but they're also making sure if she did do something, they don't mess anything up on the front end that could destroy a victory on the back end when people are expecting that victory. Think about this. So here's another question posed out your way. Imagine you're Ashlee's defense attorney. You took an oath to zealously defend your client. She tells you in confidence that Melodee is alive but hidden somewhere, and she's terrified of what will happen if she reveals the location. Do you advise her to stay silent, knowing Melodee's might be suffering? How do you sleep at night either way? And what happens to the legal system if lawyers start breaking privileges when they personally disagree with other clients? With their clients, sorry. So it's just a question. 14th Amendment, due process. And this is part of what I just discussed, but what it protects. So the due process clause prevents the government from depriving anyone of life, liberty, or property without due process of law. How it applies here is Ashlee cannot be held indefinitely without being charged with a crime. She cannot be subjected to punishment before conviction, and any detention must be reasonable in length and conditions, and she has a right to a prompt hearing before a judge if arrested. So the reality check in missing person cases, this creates a genuine challenge because without enough evidence to charge her with a specific crime, authorities can only hold her for a limited time, typically 48 to 72 hours, and it's only a missing person case. It's not a criminal case yet. Even if public pressure is intense, judges must follow constitutional requirements, and detention solely to coerce information would be unconstitutional. Unconstitutional preventive detention. It's unconstitutional, they're saying. So historical context, the due process clause exists because of historical abuses where government detain people indefinitely to extract confessions or information. While frustrating cases like this, it prevents a return to such practices. So think about this. What if investigators arrest Ashlee on a minor charge, say driving with an expired license, just to buy 72 hours to pressure her about Melodee? Is that clever police work or abuse of power? What's your thoughts? Now imagine if police did this to you because you exclaimed you knew where their missing property was. Still okay with the tactic? Where's the line between legitimate investigative strategy and pretextual detention? All right. Parental rights is another complicating factor. The constitutional foundation. The Supreme Court has consistently recognized that parents have a fundamental liberty interest in the care, custody, and control of their children. And it looks like it says Troxel versus Granville 2000. Whoever, if you guys know more, please add. So how this affects this case, unless the court has formally terminated or suspended Ashlee's parental rights, she technically retains legal authority over Melodee. This doesn't give her the right to harm or endanger Melodee, but it does affect how authorities must proceed. Removing a child from parental custody requires either 1, a court order, 2, emergency circumstances, or 3, evidence of immediate danger. And I don't know if we have any of those. The perverse dynamic. This creates a situation where Ashlee might claim she's exercising her parental authority by keeping Melodee's location private. Without proof of abuse or neglect, mirroring the legal threshold, challenging this is difficult, and even obvious bad judgment isn't always sufficient for emergency state intervention. But there is an exception I saw. Where did I put it? Child Protective Services can obtain emergency custody in most cases if they can demonstrate imminent danger, but this requires credible, specific evidence, not just suspicion or absence of information. And right now, we don't have that. We just have a missing child. So think about this question for you. Suppose Ashlee claims she's hiding Melodee from an abusive father and is protecting her daughter by not revealing the location. Without that context, she looks like a monster. With it, maybe she's a protective mother. Investigators don't always know the full story when they're making split-second decisions. What if they override parental rights and it turns out that the mother was actually protecting the child? Who's liable there? And how many rescue situations have we gotten wrong? Now, this is the part of the conversation that kind of adds that caveat, the catastrophic consequences of rights violations, but then we're going to go into the safety of the child. So actually, let me do this first before we get into the safety of the child. Let's do the catastrophic consequences of rights. So I have first evidence suppression, the exclusionary rule, the principle. Evidence obtained through constitutional violations is generally inadmissible in court, as established in Mapp v. Ohio 1961 and refined through decades of case law. What this means for Melodee's case is if authorities violate Ashlee's rights, direct statements are excluded then. Anything she says under coercion without counsel or during unlawful detention cannot be used. And remember, guys, it's all for the back end. Because let's say she did kill this child, or the child is dead and we have to investigate the death of a child. What they do now matters when it comes to accountability. Derivative evidence problem. Even if coerced statements lead to Melodee's location, that physical evidence might be excluded as fruit of the poisonous tree. So again, it's what leads to the other. So if this right here was a violation, and because of that violation, we got all these things, none of this is going to count. Cascading exclusions. Other evidence discovered through the tainted information could also be suppressed, and defense field day. A skilled attorney would file motions to suppress, potentially gutting the prosecution's entire case. So the real world example, in multiple cases, suspects have gone free because overzealous interrogations violated their rights, even when the evidence of guilt was overwhelming. The court message protecting rights matters more than any single conviction. So I want you to think about this. Here's the nightmare scenario. Police coerce Ashlee into revealing Melodee's location. They find Melodee alive but severely neglected. The defense moves to suppress all evidence as fruit of the poisonous tree. The judge agrees. Ashlee walks free, regains custody, and civil courts later award her damages for the rights violation. There's the added caveat. They award her damage for the violations of her rights. Melodee goes back to her. I mean, could you accept this outcome? If not, what would you change about the system? And what new problems would your solution create? Then you got the case dismissal. I saw this thing called the nuclear option when it happens. In egregious cases of rights violations, judges can dismiss charges entirely with prejudice, can never be refiled, typically reserved for the most serious governmental misconduct. Without prejudice, can be refiled, more common, but still requires prosecutors to rebuild from scratch. Here's the catch-22. If authorities push too hard and violate Ashlee's rights, she might walk free entirely. Even if Melodee is found alive, justice for any harm she suffered could be impossible to achieve, and the case could become a cautionary tale cited in law schools for decades. And guys, this is just the rights of the criminal. Why judges do this is not about being soft on crime. It's about maintaining the integrity of the system. If courts tolerate constitutional violations just this once, the precedent erodes everyone's protection. So think about this. You're the judge. You know everyone knows. Everyone knows that the defendant is guilty, but the police clearly violated their constitutional rights during the investigation. If you allow the case to proceed, you're essentially saying rights don't matter when we really want a conviction. If you dismiss, a guilty person walks free and you'll be crucified in the media. Your family will receive death threats, but you took an oath. What do? Be honest and really think about the pressure you face. Civil liability, the financial hammer, Section 1983 claims. Federal law 42 USC Section 1983 allows people to sue government officials for civil rights violations, and that's the civil part we just talked about. Ashlee could use individual officers, the police department, and Ashlee could sue individual officers, the police department, and the municipality. Qualified immunity might not protect officers if right violations were clearly established, and damages could run into millions of dollars. The chilling effect, law enforcement agencies already resource-strapped must balance the urgent need to find Melodee, the risk of lawsuits that could bankrupt departments, and the professional consequences for officers who overstep. This isn't cowardice, it's institutional risk management that unfortunately can slow urgent action. And that could be another thing that we're seeing here, the lawsuit. So think about this. Small town police department often have budgets under $2 million. A single civil rights lawsuit could bankrupt them, meaning no police protection for the entire community. So when the detective investigating Melodee's disappearance hesitates before taking aggressive action, is he thinking about the law or about the lawsuit? Should we blame him for protecting the department in town? What if we remove civil liability for officers acting in child rescue situations? Would that unleash more rescue or more abuse? Sometimes I think about that too when I commit to actions. I always think about the lawsuit behind the actions. Eventually, my step, what will open up to a lawsuit? Maybe not for me, because maybe I'm within my power to do that. But in the long run, maybe there's a concern with the agency I work for if I do implement this, and now they get sued. So maybe it's something that we got to rethink. And then the life-saving exception. That's the main bullet. That's the other end of this, the safety of the child, when rights can be overridden. So yes, we did the one side, but let's do this part now. This matters. The public safety exception to Miranda, legal foundation. So we revisit that again. That's New York versus Qualls, 1984. Established that police may ask questions reasonably prompted by immediate concern for public safety without first giving Miranda warnings. How it works in practice, qualifying scenario. Police have reason to believe Melodee is in immediate life-threatening danger. The questions are narrowly tailored to addressing that danger. The situation is urgent and evolving and not a cold case scenario. Example application. If police apprehended Ashlee and have credible information suggesting Melodee is locked in a car trunk in summer heat. Does that sound familiar? Little David there, little Celeste Rivas Hernandez. They can immediately ask, where is Melodee without Miranda warning? Her answer, even if self-incriminate, would likely be admissible. And the rationale saving a life outweighs procedural protection in that moment. And it's not, again, about violating the constitutional right. It just says procedural protection. So it's another perspective. Critical limitations, the exception is narrow. It doesn't allow extended interrogation. It's like, hey, where is she? All right, she's over here. Okay, good, we're good. But where is she? Well, I didn't take her. Where is she? I know you took her. Where? You got to watch. Because then you could be crossing into that violation. Once the immediate danger is resolved, Miranda protections resume. Courts scrutinize these claims heavily. False emergencies backfire badly, so you better be doing it honestly. And the subjective belief of danger must be objectively reasonable. That means that they must believe that there was a reasonable threat to this person. That's why you were able to ask that question in which she incriminated herself. But at that point, it would be admissible because you were able to justify the need. Why it may not apply yet? Currently, authorities may not have enough evidence to establish imminent danger. That's a big thing. So Melodee has been missing for weeks. No specific threats or evidence of immediate harm have been publicly disclosed. And without that urgency, the exception doesn't activate. Think about this. It's been 3 weeks since Melodee was last seen. She could be locked in a basement right now, barely alive, or she could be fine staying with a relative. Ashlee doesn't want to identify. Staying with a relative, Ashlee doesn't want to identify. The law says imminent danger must be proven, not assumed. But every hour of delay could be fatal. If you were the investigator, at what point would you invoke the public safety exception and risk having the case thrown out? Day 4, day 10, day 20? What standard would you use to decide? Then there's the emergency aid doctrine, which is extingent circumstances, legal foundation. The Fourth Amendment protects against unreasonable searches, but courts recognize exceptions when emergency aid is needed. Remember, they searched her house. Remember that. And they couldn't determine that a crime was committed there. That's important because when they searched the house, they couldn't determine. Therefore, they probably hoping if they searched the house, they could maybe get something that could lead to a charge, something that would have some level of probable cause, but it wasn't there. You saw that in the Emmanuel Harrell case too. They searched the house, they came back with the charges. Here, they searched the house and there just wasn't enough to charge. So that's search and seizure. The Fourth Amendment protects against unreasonable searches, but court recognizes exceptions when emergency aid is needed. The test: police may enter without a warrant if they have an objectively reasonable basis to believe someone is seriously injured or imminently threatened. Their primary motivation is to render aid, not to investigate or search. And the belief is based on specific articulable facts, not just hunches. Application of Melodee: if investigators receive credible information that Melodee is at a specific location in immediate physical danger in need of urgent rescue, they could enter the location without a warrant, conduct a protective sweep, and secure the scene and render aid. But they did get a warrant and they searched the property. Real world example: if a neighbor reports hearing a child scream from Ashlee's property and seeing signs of distress, police could legally enter to check on the child's welfare even without permission or a warrant. The evidence problem: anything in plain view during a legitimate emergency entry is admissible. But if the emergency is pretextual, a ruse search, all evidence gets suppressed. Courts are skeptical or even of after the fact emergency justifications, because I guess people have kind of violated that and came up with excuses as to why, which unfortunately are seen as excuses. Then it erodes the trust in when it's needed. Now think about this: as an anonymous tip comes in, I saw a child matching Melodee's description in the basement of 123 Oak Street. She looks scared. It could be real. It could be a prank. It could be someone who wants police to search the house for other reasons. Think about this real quick. If you guys have been following the David case, there was a call of swatting, and they said that they heard a girl screaming and some gunshots. That would have been enough for the police to go into the house. Maybe there's something that somebody wanted them to find in that house, because they wouldn't. I get that based on that, you wouldn't need the warrant. Food for thought. If you storm the house and it's wrong, you traumatize an innocent family and possibly blow the real investigation. If you don't act and Melodee was really there, she might be moved or killed. You have 30 seconds to decide. What do you do? What factors make this decision easier or harder? Child endangerment laws and protective custody, statutory authority. Every state has laws allowing child protective services to take emergency custody of children facing imminent harm. They have a lot of power because of the protection of the child being very vulnerable. They have a lot of power. And if the CPS and law enforcement and prosecutor, if they all can work together, you can lean on CPS. They have a lot of power. The standard varies by state, but typically requires credible evidence of serious neglect or abuse, immediate and significant dangers to the child's physical or mental health, or insufficient time to obtain a court order. Emergency removal process. Assessment. CPS investigates allegation. Determination. Social worker determines if emergency criteria are met. I mean, they're saying the lady may have a mental health concern. Maybe that's an unsafe place for a child. And would that be enough for them to go ahead and begin the process of removal or get access so they can see the living conditions? They have a lot of power. Removal. Child is placed in protective custody, foster care, relative shelter. Judicial review. Court must review the removal within 24 to 72 hours. Hearing. Parents get a chance to challenge the removal. How this applies: if evidence emerges that Melodee is with Ashlee and in danger, CPS can seek emergency custody. This doesn't require Ashlee's consent, but it does require specific credible evidence, not just her absence or non-cooperation. So again, they're pushing towards mental health. The Melodee puzzle. Without knowing what Melodee is, emergency custody orders can't be executed. It's a chicken and egg problem. Need to find Melodee to protect her. Need evidence of danger to justify overriding Ashlee's rights, and can't get evidence without finding Melodee. So think about this. CPS workers are criminally liable in some states if they remove a child without sufficient cause, but also liable if they fail to remove a child who was later harmed. The caseworker assigned to Melodee's files has incomplete information, a massive caseload, and could face prosecution either way. Now add media scrutiny and public outrage. Would you want the job? How do we expect humans to make perfect decisions under these conditions? If a caseworker errs on the side of caution and Melodee is harmed, should they face criminal charges? Let's actually break this down a little bit more for clarity. So Child Protective Services versus police. So police, okay, they investigate crimes, gather admissible evidence, and build cases for prosecution, bound tightly by constitutional protections like 5th, 6th, 14th Amendments. CPS protects children from neglect, abuse, ensures safety, and can move faster on custody or removal decisions. Their main mission is child safety, not prosecution. So there's a bit of a difference there. One is prosecution worrying about the back end. Their job is the child safety aspect. So there's your rights versus child safety. That the other avenue comes from Child Protective Services. So CPS is more flexible. Emergency removal. CPS can remove a child from a parent's custody if they believe the child is in immediate danger. Police often assist, but CPS can initiate the process. Court petition. CPS can go to a family court to seek temporary custody even before a criminal charge is filed. Judges usually approve quickly if safety is at stake. So I'm assuming these visits are going to be documented. Eventually, CPS is going to say, hey, listen, we got to do something. So that could push something forward. So it's actually good to see him go to the house. Lower evidence threshold. CPS acts on reasonable suspicion, not beyond a reasonable doubt. And that's because of the safety. The safety allows them to operate maybe one step lesser because this truly is about the child, where the prosecution technically is leaning towards the rights of the person being charged, right? So I got to prove that. Reasonable doubt. But when it comes to the safety, I'm going to lessen that standard because I may not have time to prove that. So reasonable suspicion. So you lower the evidence threshold. So CPS acts on reasonable suspicion, not beyond a reasonable doubt. That means they can intervene on red flags, even if police don't yet have enough for charges. And access to records. CPS can review school, medical, and welfare records more freely than police. What are the limitations? Now, CPS has no arrest powers. They can't arrest or force someone to talk. They must rely on police if a crime is suspected. Still need court orders for long-term custody removal or access to private property. CPS needs a judge's approval. Maybe that's what they're trying to work on now. Bound by confidentiality. CPS investigations are often sealed to protect minors, which can limit how much pressure they can publicly apply. And guys, I've had this in shows in my past where we have to find a way to get better communication with CPS and law enforcement authorities because we need a better partnership. And Constitution still applies. They cannot interrogate a parent without due process. And if their actions look like they're doing police work, courts can throw out evidence. In Melodee's case, if CPS could establish that Ashlee poses a current risk to Melodee, they could petition family court for an order requiring Ashlee to present the child, could push on the mental health issue. If Ashlee refused, she could be held in contempt of court, which creates legal leverage without violating constitutional protections. CPS might also use past history, mental health records, home conditions, prior reports to strengthen the case for intervention faster than police could. But CPS cannot just sidestep Ashlee's rights and force her to disclose Melodee's location. They still need judicial backing. So CPS does have more freedom than police because their focus is safety, not prosecution. They can move quickly on custody and use lower standards of proof, but they cannot override constitutional rights or force confessions. The strongest route in Melodee's case may be parallel action. CPS working family court angles for custody and safety, police building the criminal case, and the FBI pursuing interstate and federal violations. Now let's get to, I think we're on the last part here. 2 more parts. So then we got the federal investigation when state boundaries are crossed, so FBI involvement. The FBI can assert jurisdiction. Let's see, kidnapping, Federal Kidnapping Act, that's the Lindbergh law if a child is taken across state lines. Parental Kidnapping Prevention Act, when one parent unlawfully removes a child from another parent with custody rights. Missing and exploited children resources, FBI assists with resources, databases, and coordination. Advantage of federal involvement, multi-state coordination and resources, federal grand jury subpoenas, which have a broader reach, enhanced surveillance capabilities, and federal charges carry heavier penalties, potential leverage. Current status, if Ashlee crossed state lines with Melodee in violation of a custody order, federal kidnapping charges become possible, bringing significantly more investigative resources and potential consequences. But in this case, she just went to Nebraska, so it is cross state, but I don't think it was kidnapping. Think about this. Federal charges for parental kidnapping carry up to 20 years in prison. If Ashlee knows this, it might make her more desperate and less likely to cooperate, but the kidnapping wouldn't be there for that. So this question really is null and void. Conversely, the harsh penalty might be leveraged to get her. Yeah, guys, I look at everything. So strategic application, the investigative tightrope, what investigators are likely doing right now. This is, everybody wants to push, but this is maybe some things that they're doing now that are behind the scenes that they're getting ready to apply the pressure. So they're going to build a circumstantial case, tracking financial records, credit card, bank withdrawals, purchases, analyzing cell phone data, towers, GPS calls, texts, reviewing surveillance footage, traffic cameras, store security, ATMs, and I know they collected surveillance cameras, the footage. Interviewing associates, family members, neighbors, searching social media and digital footprints, and checking with motels, campgrounds, and rental properties. The strategy: investigators are likely trying to establish probable cause for specific criminal charges, because remember, they got to go another level higher. Abandonment, endangerment, kidnapping, something like that. Locate Melodee through means other than Ashlee's cooperation. Build a timeline that demonstrates Ashlee's actions and intent, and identify witnesses who can testify about Melodee's condition and whereabouts. Why this takes time: each piece of evidence must be legally obtained with warrants where required, properly documented, admissible in court, and sufficient to establish the elements of crime beyond reasonable doubt. Because remember, they're building their case. So think about this. Ashlee's phone record shows she was near a state park for 3 hours, then purchased children's clothes at a Walmart 50 miles away. Is that evidence of where Melodee is, or just circumstantial noise? How many leads like this should investigators chase before declaring it a dead end? What if that Walmart stop was the key and they moved in too quickly? Years later, when Melodee's case is still unsolved, will we blame them for not following that lead far enough? And the proof of danger problem. What qualifies as imminent danger? Courts generally require specific, credible information, not speculation. Time-sensitive threats, hours or days, not weeks. Objectively reasonable belief based on facts. What doesn't qualify? General concerns based on passage of time. That's kind of where we're at now. Suspicious behavior without concrete danger. We have that now. Public pressure or media attention. We have that now. And hunches or gut feelings. We have that now. The Melodee situation, after weeks missing, establishing imminent danger becomes harder. The immediacy element weakens. Uncertainty about her conditions doesn't equal proof of danger, and courts distinguish between missing, unknown status, and endangered, known threat. So missing is an unknown status. Endangered child is the threat. The investigative challenge: authorities must find evidence that Melodee is alive. She faces immediate specific danger, and time is of the essence. That's key. She's alive. She's in danger, and time is of the essence. We got to get to her now. Without this evidence, emergency exceptions to constitutional rights don't apply. Think about this. What if investigators have proof Melodee was alive 2 weeks ago, but no information since? Does that reset the imminent danger clock legally? Probably not. She hasn't been seen recently, so immediacy is hard to prove. But logically, a child confirmed alive 14 days ago is more likely in imminent danger than a child missing for years. Should the law recognize this middle ground? How would you draft that standard without creating loopholes for abuse? How the public can actually help. Report credible sightings immediately. What's helpful? Specific locations and time of sighting. Description of Ashlee, Melodee, or the vehicle. Photos or video, if available, without approaching. I saw a lady in one of the videos kind of go to talk to her when the news was there. I would hold off on all that. You could be messing up with something that's happening. So again, I think they even released something to the public, like slow down. We don't need search parties. We don't even know what we're looking for yet. Just slow down. Don't get ahead of this, because you could intervene with what we're doing. And contact information for follow-up. What's not helpful? Vague. I think I saw someone who looked like, type of reports. Internet sleuthing that creates false leads. Vigilante action or confrontation, and spreading unverified information. Why this matters: a single credible sighting could trigger the public safety exception, provide probable cause for emergency action, give investigators the evidence they need to act decisively, and establish the imminent danger needed to override certain rights. Because when they're going in, all this stuff that has to be done in the back should be done. The double-edged sword: false reports waste critical resources and time, but hesitation to report could cost Melodee's life. And the public must balance vigilance with responsibility. So it's like, you're 70% sure you saw a child matching Melodee's description at a rest stop, but the lighting was bad and you only got a brief glimpse. Do you call it in? If you do and it's wrong, investigators waste hours checking a dead-end lead. If you don't and it was really Melodee, you might have been her last chance. What percentage certainly is your threshold? 51%, 75%, 90%. And if you're wrong either way, how do you cope with that decision? And then you got to maintain the pressure on authorities, right? The constructive advocacy. Contact elected officials requesting resource allocation, support funding for missing children investigations, attend vigils and organize searches, share official verified information from law enforcement, and demand transparency in the investigation process. Destructive pressure, demanding illegal action by law enforcement, which could be what some people could be pushing, not knowing. Threatening officials who follow constitutional requirements and creating conspiracy theories about police incompetence and harassing family members or witnesses. The balance, public pressure keeps cases in the spotlight and ensures resources are allocated, but it must be channeled constructively. Investigators who feel attacked may become defensive rather than collaborative. So if you were the lead investigator on Melodee's case is getting death threats let's say you're the lead investigator on Melodee's case. The lead investigator on Melodee's case is getting death threats for not doing enough, hypothetically. His kids are being harassed at school. He's working 16-hour days, but can't share information because it would compromise the investigation. We see that with David and Celeste. At what point does he become too emotionally compromised to think clearly? Could public pressure actually make investigators worse at their job? If you sent an angry message to a detective and later learned it distracted them during a critical moment, how would you feel? And then support systemic improvement, legislative advocacy. I know I did a video earlier today about Jacqueline Torres Garcia, Mimi, and they're trying to come up with Mimi laws. Basically, more oversight with child protective services, homeschooling, a couple of things in play there. Great video, by the way, covered a lot. So legislative Amber Alert system improvements, enhanced resources for missing children investigations, technology investments, so facial recognition, database integration, training for law enforcement on balance and rights with urgency, and better coordination between agencies and jurisdictions. And then you got the community infrastructure, neighborhood watch programs, child identification programs, education on recognizing and reporting child endangerment. Remember, it's key. And support the families of missing children. Long-term solutions. These cases reveal systemic gaps, insufficient resources for child welfare investigations, lack of coordination between agencies, outdated technology and database, and insufficient training on limits and exceptions. And let me go 2 more parts and we're getting to an end. It's a lot in these cases, man, but it's good to learn. The public wants to help. This is the right way they should be helping. So you want to report credible sightings immediately. What's helpful, specific location and time of sighting. We talked about that. Description of Ashlee, Melodee, or the vehicle. Photos or video if available without approaching. And contact information for follow-up. What's not helpful? Oh, we did that. Sorry, guys. We did that. 100% we did that. The fundamental balance, why this matters beyond one case. So here's a slippery slope both directions. If we erode rights today, it's just force her to talk to save a child. Tomorrow, it's detaining anyone who might know something. Eventually, it's a police state where suspicion equals guilt, and history shows this path leads to tyranny. If we prioritize rights, absolutely, vulnerable victims pay the price. Public faith in the justice system crumbles. Vigilante justice becomes tempting, and the social contract phrase. So what's the middle path? The American system attempts to establish clear rules that protect everyone, create narrow exceptions for genuine emergencies, require evidence and judicial oversight, and accept that sometimes guilty people go free to protect the innocent. That's worth repeating. Except that sometimes guilty people go free to protect the innocent. Think about that. Everything we just discussed now, that statement is an anchor. The Melodee Buzzard case as a mirror. So the case forces us to confront uncomfortable truths. Our rights protect the guilty as well as the innocent. Justice is slow, messy, and imperfect. Emotional certainty doesn't equal legal proof. And sometimes there are no good options, only terrible choices. No good options, only terrible choices. So what we learn, the system isn't broken because it's frustrating. It's working as designed. Constitutional protection exists precisely for cases like this. Emergency exceptions provide flexibility, but must be narrow. And the balance between rights and safety will always be contested. So moving forward, rather than demanding authorities just do something rather than demanding authorities just do something that violates rights, we should understand why the constraints exist, advocate for better resources and training, report information that could establish imminent danger, support families while respecting the investigation, and push for thoughtful reform, not reactive legislation. And the final reflection is the liability question. when an action becomes actionable. The legal gray zone. So police generally have no constitutional duty to protect individuals. And that comes from DeShaney versus Winnebago County, 1989. That's actually been a recent discussion too. I've heard that a lot now. They've been talking about that a lot. However, special relationships exceptions exist. Custody, foster care, certain protective orders. We have that in corrections, by the way, because they're in our custody and control. Departments can face state tort liability for gross negligence or reckless indifference. Reckless indifference. Individual officers can be liable if they violate clearly established rights. The Melodee scenario, if investigators had evidence suggesting imminent danger but failed to act, that's kind of like the negligence side. Civil liability could attach if the inaction constitutes deliberate indifference. Yeah, so deliberate indifference, negligence. The threshold is extremely high. Negligence alone isn't enough. Okay, so you need the deliberate indifference. And courts must balance the duty to act against constitutional constraint. The impossible position, investigators face liability from multiple directions. Act too aggressively, civil right lawsuit. Act too cautiously, wrongful death, negligence lawsuit. Make any mistake, qualified immunity may not protect them, and public scrutiny makes every decision subject to Monday morning quarterbacking. I got a final question for you guys. So imagine you're an investigator. Ashlee is sitting across from you, silent. Her lawyer advised her not to talk. You're having strong suspicion, but no proof of imminent danger. Not enough to make emergency exceptions. Melodee has been missing 3 weeks. You can hold Ashlee for 48 more hours maximum. After that, she walks unless you can charge her with something specific. What do? Do you push harder and risk violating her rights, possibly letting her walk free forever? Follow protocol and hope technology or witness breaks the case, possibly allowing Melodee to come to harm? Try to build rapport and get her to voluntarily cooperate, possibly wasting the limited time you have. And be honest, could you make this decision? Could you make this decision? Would you want this responsibility? And if you make the wrong call and Melodee dies, or if you violate rights and a guilty person walks free, could you live with yourself? And again, this is just something you want to drop in the comments. So until investigators have specific, credible evidence that Melodee faces imminent danger, they must work within constitutional boundaries. It's infuriating, heartbreaking, and seemingly unjust. But if they violate Ashlee's rights, they risk losing any chance of holding her accountable, and they create procedures that could be used against innocent people for generations. The system is slow because it's designed to be careful, and sometimes tragically being careful costs lives. We accept this cost because the alternative, unlimited government power, would cost even more. So it doesn't make the cost any easier to bear, especially not for Melodee. Guys, that's why you see the partnership where you have the law enforcement side, the prosecution looking towards the back end, but you have the CPS side looking for that safety. And that's the balance, right? Versus safety of a child. Hope you enjoyed the content. As always, guys, stay safe.